Hey, everybody. You know all about trademarks, even if you think you don't. You literally probably eat trademarks, wear trademarks, sleep on trademarks. I know you're like, what is he talking about? But that's the exciting world that we're going to talk about today. Katie introduced me to Frank, and Frank has been just a big lifesaver, not only for me, but I've recommended people to him. Even this recent Good Vibes Club, he came in and did so much for them. So, welcome to the show, Frank.
Thank you very much. It's great to be here.
Yeah, well, first of all, I like your haircut.
Of course you do. We go to the
Right.
same barber.
We got that going on. But Frank, trademarks is this invisible layer. And Katie, I know you're with patents. Let me ask one question to Katie first. Katie, do patents and trademarks ever overlap? Or are they kind of just two different lanes that never talk?
Oh, yeah, no, they overlap a lot because a lot of times maybe someone will patent their product,
Mm.
right? And then they simultaneously need a trademark on the
Oh,
name of the product. So there can be a lot of overlap between the two.
sweet. Okay. So Frank, let's jump right into it, man. How does one just wake up and say, I want to be in trademarks?
Yeah, well, that's an interesting story. I went to law school at night and I took a class strictly because it fit my schedule, not because I had any particular interest. It was a class on trademarks and copyrights. I actually was planning on being a malpractice or a divorce lawyer when I went
Okay.
first to school. I took this class, and frankly, I fell in love with the area. And my professor at the time was Evelyn Summer. Sadly, she's passed, but she was at the time chief patent and trademark counsel to Champion International. And so she was great about, kind of shepherding me through. She had me down to their offices for
Mm.
lunch, told me kind of about what a career in trademark law would look like. And I have to say, it's been great. I had some interesting experience trying to find a job. We'll say that. Just out of law school, no experience, obviously. Well,
Sure.
I shouldn't say. I clerked for a IP boutique in Stamford, Connecticut, which was great, but not kind of the experience that like a law firm would be looking for.
Yeah.
So one of the nicer rejection letters that I got was actually from this lawyer in Washington, D.C., who said, sorry, we can't offer you a position. You might want to consider trying to go to the trademark office as a trademark examining attorney. Hadn't even thought of it, to be perfectly honest. So, long story short, I applied, got a job, and I started my career as a trademark examining attorney with the trademark office. Was there for a few years, and then went to an IP boutique in Manhattan, and then been here at Wiggin nearly 31 years. So, um,
Wow.
trademarks and copyrights is all I've ever done. I don't have kind of the more general background that a lot of people have,
Yeah.
especially here we're a general practice firm at Wiggin. So there's a lot of people who, do much different things, which has been great for me because I've learned a lot as I'm here in other fields as well.
Sure.
But yeah, that's how I became a trademark lawyer.
I
I
love it.
love
I
it.
love it.
It's I think it's a more genteel practice from my perspective. That's not to say that that, people that are more difficult to deal with. I'm trying to be nice, but as a general rule, and I'm sure Katie probably says she feels the same way. It's
Yeah.
more of a collegial environment. And to
Okay.
your earlier point about like patents and trademarks overlapping, I say same church, different pew. There's patents, trademarks, copyrights, and trade secrets, all of which are in the IP realm.
Sure.
But of course, different disciplines. I can't do what Katie does. She has a technical degree. I do not.
Yep.
So even if I wanted to, I couldn't be a bad lawyer.
Yeah.
But I'm happy with the trademark and copyright field.
Perfect. Okay. And Katie, I can hear Frank pretty good. Frank, maybe move up just a little
Sure.
bit.
Sorry about that.
No, you're great. You're great. I could hear everything. I just want the podcast people to hear it. So,
Sure.
Katie, you recommended Frank to me, and Frank has been amazing. I mean, we've done everything from the book, cover, like the title of the book, because it turned into, that's even something Frank maybe will nerd out on, is can you do book titles, and if not, how? There's ways that you can make it happen. But Katie, what made you say, hey Kary, you need to talk to Frank? What kind of popped in your head?
Oh yeah, no, I think Frank is Frank's experience at the trademark office, I
I
think,
didn't
is
know
so
that. Yeah.
valuable because he has such a great perspective. And I think in today's examination climate where it's very unpredictable,
Yeah.
it's great to get Frank's
Yeah.
opinion on things because it's changing so much, sort of
Yeah.
like the patent office. So Frank, is very in tune to what's going on there. And so he's able to really help clients strategize on what's going to kind of pass the mark for trademarks and what might not. And he's always, ahead of the game of where things are going based on his depth of experience.
I agree.
Yeah, so if you don't mind, I'll just jump in on that. So yeah, Katie's exactly right. I use the term today's examination climate, probably every time I talk with Katie. And frankly, it's true. Like, it's just a different world today. I think I started my career as an examining attorney. My eldest daughter is an examining attorney at the trademark office. So I'm not maligning examiners. I just have to kind of call it how I see it. And it seems to me like they're getting more and more conservative as it relates to registrability criteria, from statutory, like substantive, likelihood of confusion, surname, geographic, whatever, substantive reasons, or on formalities like specimens of use. So they're just seemingly getting more and more stringent in their requirements, at least from my perspective. So it's I tend to be conservative. So there's times when I think it can get a little frustrating. I'll say to a client, "Yeah, I don't think the specimen's going to work," and they're like, "You mean why shouldn't it work?" And like, "Here's the mark," and whatever. And I'm just, I go kind of through this stringency that the examiner's going to look at it with.
Yeah, through that lens. Yeah, definitely.
Yeah, and again, I'd rather there not be an issue, or at least if there's going to be an issue, that I'll have told, the client about the issue, potential issue. If it happens, okay, then they're not surprised. If it doesn't happen, fantastic. But even with that, like, I have to be honest, there's time when, I say, oh yeah, this should go through without an issue, and it doesn't. And there's times when I say, yeah, this is never going to work, and it goes through. So, it sometimes is kind of luck of the draw as to the examiner you get, and kind of stars align, I guess.
But let's talk about that, because it is almost a tolerance for risk. Like I've been on my side, you've been on your side, you and Katie, and you both have told me at times, like, hey, here's what we suggest, here's the appetite for risk. Would you like to go forward? Would you like to not go forward? You're making an investment. And there's been times where I've said, hey man, I'm an entrepreneur. I know we might not get this, but it's really important. So maybe both of you can weigh into that, because I think that's unique with Wiggin, that you give expert advice. You want the client to listen. Hopefully I'm teachable, but there is a time where I need to just pull the trigger and make something happen too. So what do you each think of that in terms of your approach?
Katie, I'll let you go first.
Okay. Yeah, no, I think ultimately it's the client's decision, right? We can provide a legal recommendation of here's what we would, recommend. But if the client wants to, try because it's something important to their business, then I'm all for that.
Okay.
But I think it's kind of setting expectations correctly so that the client isn't upset then when things maybe aren't as easy to get through, right? Or take more rounds of arguing, or,
Sure.
kind of different approach. So sometimes it might work, and we might need to just kind of really think through how to approach it in a creative manner to kind of help try to optimize the outcomes.
Yeah.
Yeah, I agree 100% with that. Again, I tend to be conservative, but at the end of the day, you're right. It is ultimately the client's decision, and as long as I advise the client what I expect,
Right.
and say, look, ultimately it comes down to a business decision as to whether you're comfortable with the risk, and at the end of the day, it's your money. So I try to be mindful of that, and to Katie's point, set expectations, so that you say, okay, yeah, Frank, you explained to me all the potential issues. You told me what the costs are. I'm willing to take the risk and incur these costs.
Yep.
If it works, great. If it doesn't work, okay, well, we gave it a shot. I hate, I guess maybe it stems back from when I was an associate, you got calls from clients saying, why didn't partner X tell me that this was an issue? I would never have filed. I would not have changed marks. I would have whatever. And I do genuinely, kind of take it personally for clients. I try to make sure that they understand everything and that they make an informed business decision. Again, at the end of the day, as long as they understand what the potential risks are, then that's fine. Then the chips are going to fall where they may, but they're not going to turn around and say, why didn't you tell me this, Frank? I've never done this.
Right.
So yeah, that's kind of where I am.
That's a great perspective. I like that. Yeah, and I mean, just as a customer, client of Wiggin, I would encourage people. To me, that's rare. What I like about Frank and Katie is very accessible, because it does feel like, especially when you're in the beginning doing your first of anything, patents, trademarks, you are going into the fog and you need a guide, a Sherpa who's been there before. So that's cool. I feel like, I don't know, Frank, maybe I'm on my 12th trademark now or something like that, with multiple countries now. So I kind of get the process, but let's go speed round here. Maybe you can answer first question: books, trademarkable, not trademarkable?
Yeah.
How?
Trademark, as it relates to titles of books, you can get a trademark registration if you have a series of books. You cannot get a trademark registration for a single title. Trademark Office just doesn't consider that. I don't know why, but they don't consider that to be a trademark use, a single title. So if you have a series, fantastic, you can register it. They will likely ask you to include in your recitation of how you describe it, like a book, a series of books, not just a book. Again, you may say that you might get it through as books in the field of whatever, but you heard books, right? So again, more than one book. So yes, books, titles of books are registrable if there's a series. If there's only one, no, not as a title. To say like, okay, well, what about, I know there were more than one Star Wars, but let's just assume there were one Star Wars book. And they say, they have registrations for various other things, not so much the books. They have, for toys, for clothing items, for bedding, for whatever, But if it's literally just one title, the Trademark Office, assuming they ask, if you come in for books in the field of fiction, for example, the examiner may not make you, prove that you have a series of books. You've said books, so they're going to take you at your word. So you might get it through, but the truth of the matter is, technically, if you only have one book, you're only supposed to have, there's not supposed to be an ability to get it registered.
So the author should almost know coming in, hey, this is the first, but there's going to be more. At what point do you need to declare that it's a series? In other words, you get what I'm saying? Like, is it almost like retroactive where you have to have two out?
Yes, it is. In fact, in a technical sense, yes, you're supposed to, if you get a registration or when you get a registration, you're supposed to have a series of books, which of course is two or more, to your point. Sometimes the trademark examiners are tough and they'll say, show us evidence that there's a series here. Sometimes they'll take you, they do, sometimes take you at your word.
The plans come. Yeah.
You're saying there's a series, then they'll take you at your word. It does depend on the examiner.
Perfect. Okay. So Katie, on that point, do you often get that question too? Like, do authors ever come to you, or maybe they're patenting something and they have a white paper or written material around it? Has that ever happened, book with patent, or not too much?
Oh yeah, it happens all the time. A lot of times after someone files a patent, they might want to write a book about their process,
Okay.
or their methods, or maybe their research. So I think this is something that comes up quite a fair amount of
Interesting.
the time.
Okay.
The other side of that, to remember, is the copyright side.
Yeah.
So there's an ability to register copyright.
Yes. Yep. And Katie, I mean, let's go on that for a second. With Anthropic's $1.5 billion lawsuit, 500,000 copies of books stolen to train LLMs, 3 of mine were in there, even though I've written 14, but only 3 were essentially stolen. But I needed the copyright, or I couldn't have gotten the $3,000 per book.
Yeah,
True.
that's right. Yeah, we had to go through the process of getting your copyrights registered, so then you could fill out the claim form there.
Yeah. So all right.
On that, if you don't mind. So
you go for it. Yeah.
People find the situation, where, okay, we have a problem and I never sought registration for it. What do I do? Well, you can get an expedited registration. It's costly. There's an $800 surcharge for the expedited handling, but I will tell you, I filed one this past spring, and we filed it on a Friday, and we had our registration on Monday. So
wow,
they do act quickly, or can act quickly. Let's put it that way. And if you're in a situation, to your point, you must have a registration. If you're going to either file a claim or bring a lawsuit. Sometimes you got to bite the bullet and do what you got to do.
Yeah, no, that's great. You Are an IP Company's not a series, but what we did do was we naturally have a course. Katie and I are also going to be doing workshops around it. So that, Frank, is another way to get a book through, is to have other things besides the book. Is that true? Can you comment on that?
Yes. Yeah. So again, educational services, registrable, as long as they're provided for the benefit of somebody else. If you provide consulting services under it, then that's, again, a business service in Class 35, something that's entirely registrable.
Wow.
So, there's ways of protecting something where you might say, okay, well, perhaps this one specific title, okay, maybe we can't get a registration for the title, but we can, cover all the area around it, and what we do with the business that's associated with the mark.
I like that. So, for example, Working Genius is a assessment and a certification for Patrick Lencioni's book. So he could essentially say, hey, I want to trademark Working Genius if it's available, because it is more than just a book.
Exactly. Yes. And to your point, if it's available, things can be available in one particular class. When I say class, I mean the U.S. Trademark Office is the member of the Treaty of Nice. We classify goods and services by numeric numbers. It's just an agreement that we have with many countries around the world. So theoretically, we should all be similar in how we identify and classify goods. Books are in 16, clothing in 25.
And there's 45 in the U.S.?
There's 45 numbered classes, and then there's certification mark classes A and B, and collective membership classes 200. So,
wow.
But 45 numbered classes. We in the United States have the certification mark separate, A and B, and the collective membership class number. The international system does not recognize those, so that's somewhat of a problem as it relates to if you're going to seek registration outside, as you know, Kary. When you're going to seek registration outside, excuse me, the United States, if you're saying, well, this is a certification mark in Class A, your foreign lawyers may say, yeah, well, we don't have Class A in here in Brazil or wherever. So we're going to put it to the closest numeric class that covers kind of what it is that you're doing, what you're certifying. And so if it's a product, like say a computer-based product, they're probably going to put it in 9. If it's a computer service-based certification, then it's going to be in 42.
Wow.
But that's how they match. They don't recognize those are specific to us. We file a 1 through 45. To your point, Kary, you're exactly right. But other than that, they don't recognize those specific classes.
Perfect.
So they have to work around it.
Okay. So Katie, back to you. You said a few months ago, as we were kind of giving my whole businesses an IP look, you said, hey, you may want to trademark your name. Now, again, people listening to this might be like, well, that's weird or that's arrogant. And yet Frank can comment in a moment how I'm going global and how maybe trademarking my name is really smart. So Katie, what kind of motivated you to say you might want to do that? Like, what was your thoughts?
Yeah, I think the thought there was that you were developing a lot of branding around your name, right? And you were using it as a marketing tool, right?
Yeah,
so I thought,
website. Yeah.
Yes, exactly. And your domain, right? And so I thought, this could be a potentially good reason to protect your name. Now, if you're just looking to protect your name, but you're not really using it for certain things, it might be, Frank can weigh in on this, but I think it's going to be tougher to trademark it, right? But I think there's been a lot of increase of people, especially like celebrities, right, protecting their naming because they're selling products under their name. It's a branding opportunity, basically.
Frank, is it like trolls, like we call them cyber squatting, where you get a domain name and you basically hold it hostage? Is it almost like that, where let's say I develop a disgruntled person who doesn't like me or whatever? I mean, is it possible that they block me and try to grab a name? Have you ever seen that done?
Yes, it is possible that to Katie's point, you do a lot with your name, so that's you may be different. Like from some people say, well, I just would like to have a registration for my name. To Katie's point, you have to use it in the United States to get a registration. Not necessarily true outside the United States, but in the United States, to get a registration of a trademark or service mark, you have to use the designation as a mark. It just simply won't give you the registration. So that sometimes creates an issue in terms of, to your point about domain name. Somebody could theoretically take carryoverrunner.com and if they don't have a real reason, well, how that plays out could be potentially interesting. There's the uniform domain name dispute resolution policy that says, if somebody registered a domain in bad faith, well, then there's action that can be taken around that. What establishes bad faith? That's a different question. If they say, oh, sure, Kary, I'll sell you back your name for, your domain with your name for $1 million. Well, that could be evidence. That offer to sell back at $1 million could itself be evidence of bad faith.
Yeah.
If they say, well, it cost me, $300 to register the domain, which seems high to me, but who knows? Then they're looking to be compensated for what they spent. That to me is reasonable.
Right.
At the end of the day, like I tell clients, look, if you can get this for like, 5,000 or under, you might as well just, as unpalatable as it might be, pay the money and get the bird in the hand rather than two in the bush. Because,
Yeah.
Between filing the complaint with the UDRP complaint and then the legal service charges, you're going to wind up at 5,000 before it's over.
Yeah.
So you might as well just take the sure thing, because you never know. There have been people like Bruce Springsteen, who have gone, filed a UDRP proceeding and not been successful. So,
Wow.
So it happens. Again,
Yeah.
one would think, oh, I'm famous, I should have no issue. That doesn't always follow.
Yeah.
It may follow most times, but it doesn't always.
One that I saw. Yeah.
Go ahead.
I was going to say, one that I saw recently that made the news was that somebody bought Lambo.com for, and they I think they paid $10,000, and they went to Lamborghini and said, hey, you owe me several million. The interesting thing with that one is that the court sided with Lamborghini and said, you now must pay, and you're out 10,000.
Yeah. They ordered the transfer to them, to Lamborghini. Yeah.
So they must have some good lawyers over there, because
right? And I think Lambo is a recognized, abbreviation for Lamborghini.
Yeah.
So I think if you asked a consumer, you said Lambo, what does that mean? They're going to say Lamborghini, right?
Yeah.
So it's recognition as a mark. Now, it's not Lamborghini, the full mark, but that doesn't necessarily mean that they wouldn't have protection for Lambo as a recognized.
Wow.
One, but as a recognized abbreviation. If consumers recognize it, then it serves as a source indicator. That's a mark. An indicator is origin. So that doesn't surprise me that a court would do that, especially given you want the domain. Give me millions of dollars. They're going to say, yeah, good luck.
Yeah. So Katie, as we kind of land the plane here, we're almost at the 30-minute mark, but what other things would you encourage the person just wading into IP, whether it's patent, trademark, how they fit together? I don't know, any thoughts or even a question for Frank, whatever you think.
Yeah, I think maybe, Frank, the one thing we didn't talk about, and this comes up quite a bit, is the difference between trademarks and trade dress, because this is a common question, and maybe if you just want to tell us about that a little bit.
They're both, yes, absolutely. Thank you. So, trade dress actually comprises two different things. It comprises product configuration and product packaging.
Okay.
People very often lump them together, but they're two different standards of protection. Trade dress can be inherently distinctive. The Supreme Court has ruled that product configuration cannot. It doesn't matter how funky of a product configuration it is. Product configuration, in other words, the way something is designed. So it doesn't matter how funky it might be. The Supreme Court has said product configuration can never be inherently distinctive. There are two different standards. Trade dress is protectable, in the same sense that a trademark is. It's just, you have to look to what are you talking about in terms of the standard for registrability.
I gotcha.
And that's true for marks too. Like, a service mark. Are you using it as a service? Because if I'm just advertising my own services, well, I'm not providing what's considered a registrable service. I'm just advertising my own product. That's not a service, because it's not for somebody else. The service mark has to be provided for the benefit of somebody else.
Interesting.
Again, whatever you're talking about, trademark, service mark, trade dress, certification mark, collective membership mark, you have to look to the standard for registrability, and that's how you advise your client. Look, here's what you need for each, for the various types of marks.
So quick examples would be, perhaps, I've heard, correct me if I'm wrong, a Coca-Cola bottle. Is that an example of what?
So that's a product configuration. It could also theoretically be considered trade dress, depending on exactly how it's used.
Yeah.
But
Because I've heard, I could be wrong, but I've heard that Coca-Cola bottle.
It's a registered trademark.
Yeah.
It is. Yes. So it is a registered trademark, has been a long since a registered trademark. Coca-Cola is, as I'm sure you are aware, a famous mark. So kind of that bumps up protection. So not only do you have trademark protections, but you have federal dilution or anti-dilution technically protections as well.
But that's really interesting. Let's take Coca-Cola, for example.
Sure.
So Coca-Cola has a trade secret for their formula.
The formula, correct.
They have a trade mark for the name. They
probably have patents, right, Katie? I mean, I'm assuming.
I'm assuming, yeah.
I mean, I don't know for a fact, but my
guess is. So that's like an example of IP stacking.
Yeah, exactly. And so the reason that trade dress in this instance is important is because, and Katie can speak more to this than I can, but when you talk about a patent, it ultimately becomes public, right? So at first, no, it's not public, but ultimately, once it's published, it becomes public knowledge. Whereas a trade secret, provided it is kept secret, never becomes public knowledge. So there's sometimes when people will forego patent protection and they'll go trade secret because they, whether this is right or wrong, I don't know, but they ultimately think that, they'll get more mileage or a longer term.
Yeah.
Or potentially forever if they keep the trade secret.
Wow. So let's end with that. Trade secrets are forever if you maintain the secret status. Patents are 15 or 20 years, Katie, based on plant, design, or utility.
Yep, that's right. From 20 years from filing, if it's a utility application, 15 years if it's a design patent.
Sweet. And then trademarks are
10 years.
10 years, and you have to show at 5 years.
Between 5 and 6. Yeah.
Okay. So now you're seeing this, folks, and then copyrights, I think, are the author's life plus 70 years.
Correct, unless it's a work for hire, then it's 95 years. But yes, that's absolutely correct. The one comment I would make on trademarks is trademarks, as long as you continue to use the mark, are renewable for 10 years, every 10 years for ad nauseum.
Wow. So, folks, this is, again, a lot of strategy here, and Wiggin and Dana and Katie and Frank and their whole team of incredible lawyers will help you navigate, because you don't want the same thing for all strategies. There are different types of strategies. And then Frank, you're very familiar now with instant IP, whether you wanted to be or not, but you know that I just came from, I was mentioning San Diego, and Dan Sullivan's having everybody in the room fill out thinking tools, and a lot of what they're putting on that paper, although it's an unregistered copyright, the moment it's put into a medium, there's no timestamp. And so maybe just, I'm curious, maybe just for you, because you can put something on instant IP, then blockchain, show it in a smart contract, timestamp it. Katie and I have talked a lot about that, but do you think that that's helpful? Because even going in the trademark process later, you're going to need to show evidence of first in commerce, first use. And so some of that makes the work easier.
Correct. Yes, it's evidentiary. Whether it's the exact date that you claim is a different question, but it does tend to show, at least, from a solid evidentiary standpoint, that this was something that was created and recorded to the blockchain through your process. So again, you say, well, recording something on the blockchain isn't used as a mark, and that's really what governs, as it relates to trademarks, use of the mark in commerce. But to your point about first use, excuse me, I think it can help to establish kind of a chain of events.
Sure.
That no pun intended, that when you came up with the idea and the progression of that idea through
Sure.
to when you actually commercialize it.
Love it.
So yeah, I think it's great.
Perfect. Well, Frank, thanks for being here. Katie, thanks for introducing Frank to me, because he's been a real answer to prayer. And now I'm actually encouraging my friends and Chris Gio, Good Vibes Club. So other people are getting the benefit. So thanks, Katie, for bringing him too.
Oh yeah, Frank is awesome. So I'm glad you guys could connect.
Awesome. Well, thanks, Frank, for joining us today. And
My
if
pleasure.
people,
Thank you for
yeah,
having
if
me.
people do want to connect with you, they just go to Wiggin and Dana and then look at the profile.
Yep, Wiggin.com.
Wiggin.com.
We're all there.
Perfect. All right. Thanks for being